Good morning, everybody. Good morning to today's episode of the Law of Self-Defense, a impromptu early Sunday morning show. Again, not one that I planned to do. I planned to do a show after church, but the afternoon turned out to be busy for me. So we're doing it before church. So early morning show for us. And I'm not going to do a lot of time introducing the show. It's part two from yesterday's show. We're doing a reading of the Alec Baldwin defense motion to dismiss the grand jury indictment against him, a ridiculous motion to which the special prosecutor Kari Morrissey has now responded, and we're with heat, spicy heat. I'm not going to get to Kari Morrissey's response today. That'll be tomorrow's show. But I wanted to take today to finish up the reading of this ridiculous motion to dismiss the grand jury indictment. I put a lot of background in yesterday's show, which turns out to be part one of three. I stupidly thought I could cover all of these motions in one show, but it's going to be three shows. So yesterday was part one, a lot of background there. I recommend you look at that one before you look at this one. So the link to part one is there. Same thumbnail as today, just says one of three instead of two of three. Tomorrow will be, of course, three of three. And this is what I mean. So today's show is two of three. We're completing the reading of the defense motion for dismissal of the grand jury indictment. Really silly stuff. But really, we have to get this done before you can understand appropriately the context of Kari Morrissey's response, which we'll cover tomorrow. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Thank you all for joining me this early on a Sunday morning. It's much appreciated. And with that, let's go ahead and launch the formal start of today's show. And today's show is brought to us by none other than Law of Self-Defense itself in the form of our upcoming, less than a week away, Law of Self-Defense Advanced class on Saturday, April 20th. This is our live full-day class taught live by me, streamed to you at your computer that teaches you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. Saturday, April 20th. We only teach this class twice a year, folks, twice a year. So if you miss next Saturday's class, and it is next Saturday, we're getting really close. It'll be at least October before you have the opportunity again. Can you afford to wait that long? Do you know when you're going to be attacked? When you'll be compelled to defend yourself? This insight and expertise, this knowledge of how to be hard to convict has to be on board before the fight happens. It doesn't help to learn it afterwards. And we're still in the early registration period. Today's the last day for that, by the way, to get 50% off the normal registration at lawofselfdefense.com/advanced. If you go to that website, you'll see we have a list of more than 100 questions, use of force law questions we answer in plain English. We cover not just defense of yourself, but also defense of others, family, neighbors, colleagues, strangers, like an active shooter event, all different. We cover defense of property, the many forms of property with many different degrees for lawful use of defensive force, all the way from your highly defensible property like your castle to temporary castles like hotel rooms, RVs, tents, to least defensible property like your stuff. And believe it or not, your pets are least defensible property for use of force law purposes. We cover consciousness of guilt evidence. We cover self-defense immunity. We spend almost an hour on talking to the police in the aftermath of a use of force event. It's a much more subtle communication than I think many of you expect. Many of you have been taught some self-defense law in the past. I'm here to tell you most of what you've been taught is almost certainly wrong. There's a lot of bad information, misinformation out there on use of force law, and the law doesn't care. The courts don't care. The system doesn't care what you thought the legal boundaries for use of force were. They only care what those boundaries actually are in the actual law, which is what we teach, and whether or not you stayed within those boundaries. You can step outside those boundaries with all the good faith in the world, and off to prison you go. Don't let that be you. Don't be easy to convict. Be hard to convict. Join us Saturday, April 20th, lawofselfdefense.com/advanced. And by the way, if you have a conflict for next Saturday, and I get it, the weather's getting good, register anyway, because we'll make the playback, the recorded playback of the class available to all registered students for 2 weeks after the class. So you'll be able to watch it at your leisure over that 2-week period, even if you can't join us live. Again, that's at lawofselfdefense.com/advanced. And with that said, let's jump right back in to the second half of the reading of the defense motion to dismiss the grand jury indictment against Alec Baldwin for manslaughter in the killing of Halyna Hutchins on the set of Rust. I said I wouldn't go over a lot of background, but I do want to cover just one particularly important part, and that is to keep in mind what the legal question is in this case. Because in this motion, the defense is bringing up all kinds of stuff they'd like to talk to the grand jury about that has nothing to do with the legal question in the case. So Alec Baldwin is charged with manslaughter, involuntary manslaughter, reckless manslaughter in the death of Halyna Hutchins. The basic facts of the case are they are on the movie set of Rust. Alec Baldwin's a lead actor in the movie. He's preparing for a shot inside a church. He's sitting on a pew. He's practicing presenting his Western-style single-action revolver from a holster and pointing it towards the camera. While he's doing this, the gun discharges, fires a real bullet, which should not have been in the gun, of course, fires a real bullet into Halyna Hutchins completely through her body, breaking her spine, and the bullet ends up lodging inside the body of director Joel Souza, who was immediately behind Halyna Hutchins. Halyna Hutchins being a cinematographer who was setting up the camera for this shot. Alec Baldwin's been charged with involuntary manslaughter. Now, the elements for involuntary manslaughter on the facts of this case, let me take a look at the actual statute first. So the relevant statute, New Mexico Statute 30-2-3. In fact, I'll pull this up on the screen so we can see it. Manslaughter is the unlawful killing of a human being without malice. If there were malice, intent to kill, it would be murder, not manslaughter. Involuntary manslaughter consists of manslaughter committed in the commission of a lawful act that might produce death without due caution and circumspection. How does that translate into the facts of this particular case? What does the state have to prove that a death was caused without due care and circumspection? It has to prove the following. First, that Alec Baldwin pointed the muzzle of the gun, which he knew to be a real gun, in his hand at Halyna Hutchins. Well, we know that's true because the bullet that came from the gun's muzzle, struck Halyna Hutchins. So necessarily, the gun was pointed at Halyna Hutchins. Second, that he pressed the trigger in a manner designed to fire the gun. And to fire the gun, he had to both cock the hammer and press the trigger. We know this is true from FBI forensics examination after the fact. Third, he failed to ensure that the weapon did not contain a live round. Well, we know that's true too because the weapon did contain a live round. And he made no effort to ensure that wasn't the case before he pointed the muzzle at Halyna Hutchins, cocked the hammer, and pressed the trigger. And fourth, the intended discharge of the bullet into Miss Hutchins killed her. That's also uncontested. So all these facts are indisputable and uncontested. There's lots of other facts the defense would like to talk about, like the fact that, well, the armorer is theoretically supposed to make sure there's no live ammo on the set. And the first assistant director, David Halls, he has overall management for safety on the set. And the assistant director, in whose body the bullet ultimately lodged, feels that Alec Baldwin was not acting negligently. All of that is irrelevant to these four elements. So when we hear in the defense motion that the state engaged in misconduct because they did not share relevant or exculpatory information with the grand jury, the stuff the defense is talking about is stuff like other people's personal feelings about whether Alec Baldwin should be held responsible. But evidence, proffered evidence, is not relevant exculpatory evidence unless it tends to negate one of these criminal elements or raise a legal defense. But they've raised no legal defense. They've only, well, done smoke and mirrors, really. But that's where we are. This is the legal question. Did Alec Baldwin point the muzzle of what he knew to be a real gun at Halyna Hutchins? Yes. Did he cock the hammer and press the trigger in the manner designed to fire the weapon? Yes. Did he fail to first ensure that there was no live rounds in the gun? Yes. Did the bullet that discharged, was that the the cause of the death of Halyna Hutchins? Yes. So as I've said, from the day after this event happened, when I wrote up my first analysis, unless there were some bizarre alternative facts, intervening facts, like the set collapsed on top of Alec Baldwin and he unintentionally fired the gun in that sense. But nothing like that happened. So absent that kind of intervening event, this is involuntary manslaughter every day of the week and twice on Sundays, which is why the defense for Baldwin is being so extreme, because they know that if this goes to trial in front of a jury and that jury does its job and applies the law to the evidence as instructed, there's no way their client's not convicted of felony involuntary manslaughter, which remarkably only has a maximum of 18 months in prison in New Mexico. All right, so now let's jump, with that background, let's jump back into this whiny, pathetic, histrionic, not law-based motion by the Alec Baldwin defense team to ask the trial court to dismiss the grand jury indictment against Alec Baldwin. This is where we ended yesterday. This is where we'll start today. Take a quick look at the comments. All right. So we're on page 33 of this 59-page motion. I'm going to try to get through all of it before my voice gives out. Move this over so I can read it myself. Here we go. B, the special prosecutor intentionally withheld exculpatory evidence while deflecting the grand jury's inquiries about this evidence. By the way, lots of claims of misconduct by the defense legal team here, directed at Special Prosecutor Kari Morrissey, who I hold in the highest esteem as a defense attorney and in her capacity here as special prosecutor. Continuing. Other than Hancock, who was the lead investigator of this manslaughter, Morrissey, Special Prosecutor Morrissey, did not present any of the witnesses identified in Baldwin's alert letter. So the alert letter is a letter the defense sends to the special prosecutor or any prosecutor to present to a grand jury. It's basically their side of the story and witnesses and evidence they'd like made available to the grand jury. Morrissey didn't present any of the witnesses identified in Baldwin's alert letter. Well, first of all, she didn't, because she's not obligated to present it. She's obligated to make them available, to tell the grand jury, if you'd like to hear from these people, you have the power to compel them to come. You can subpoena them. But it's up to the grand jury whether to do that. Also, none of these proposed witnesses had any relevant knowledge of the event. None of them had testimony that would influence those four elements of the crime of manslaughter. They were people like Joel Souza, the director, who was shot in the shoulder, and David Hall, the first assistant director, and a couple of other people who were going to say, well, we like Alec Baldwin and we don't think he did anything wrong. That's not relevant evidence to the charge of involuntary manslaughter. Continuing. And Special Prosecutor Morrissey did not ask Investigator Hancock proper questions to elicit exculpatory information. Who decides if the questions were proper? The defense? They get to decide? Morrissey never contacted Baldwin's witnesses to ensure they were available to testify. That's not her obligation. Morrissey notified the defense of the date of the grand jury. It's their job to make sure their witnesses would be available, even though the court ordered the state to make Baldwin's proposed witnesses readily available to testify without scheduling disruptions. Well, that's the defense job. The state knew it was obliged to do so, but it excluded these witnesses from the grand jury proceedings anyway. No, it didn't exclude them. It informed the grand jury that these witnesses were available if the grand jury wanted to hear from them. The state accomplished this in two ways, this supposed exclusion. First, Morrissey did not explain the meaning or purpose of Baldwin's alert letter to the grand jury. She introduced the letter at the beginning of the proceeding by stating simply, "There is a grand jury alert letter from the target for your consideration." She then proceeded to read the alert letter into the record verbatim, without explaining its practical significance, why it had been submitted, why it was being read, or what the grand jurors were supposed to do with it. And that's all Morrissey's obligated to do. By the way, you know what the defense could have done with their alert letter? They could have started off the alert letter with explaining its practical significance, why it was being submitted, why it was being read, and what the grand jurors were supposed to do with it. But the defense didn't put that in their letter. Morrissey literally read the letter to the grand jury. What the grand jury heard could have been whatever was in that letter. Continuing, nor did Morrissey explain that the witnesses identified in the letter were available to testify and that the grand jury was obligated to request the presentation of exculpatory and relevant evidence. Again, this is smoke and mirrors. These witnesses had no exculpatory relevant evidence to offer on the actual legal arguments in the case, those four elements of manslaughter. Instead, Morrissey conveyed the exact opposite impression. Before reading the alert letter, she had already dictated who the witnesses would be, informing the grand jury that this morning I will be presenting to you a case where Alexander Baldwin is the target. The witnesses in this case will be Corporal Alexander Hancock, Marissa Popple, Michael Haig, Brian Carpenter, Ross Adiego, Lane Looper, and Connor Rice. Well, those will be the witnesses the state's presenting. And then the grand jury is given the option to call other witnesses if they wish. Are the witnesses identified in the alert letter that was read to them? Continuing, and after reading the alert letter into the record, Morrissey made no effort to explain the letter's purpose. That's not her job. She simply stated, that concludes the grand jury evidence alert letter from the target. So there are witnesses ready to testify now. However, it depends on what you want to do. Do you want to take a break to consider the alert letter? Or do you want to just begin hearing witness testimony? Morrissey never explained or even attempted to explain what it meant for the grand jury to quote unquote consider the alert letter, that they could ask for any witness or document identified in the letter, and in fact were required to order exculpatory evidence to be produced. Again, all the documents were made available to the grand jury in a box right there in the room. And the grand jury was informed they could subpoena any witness if they wanted to hear from that witness. And they're not required to order evidence unless it's actually exculpatory. And it's not exculpatory unless it's relevant to the criminal charge, tends to negate an element of the criminal charge, or raises a legal defense. And none of this offered evidence by the defense in their alert letter did that. Continuing, once again, Morrissey's statement communicated that the opposite was true. Her message was that the grand jury could consider the alert letter, read it themselves. Well, that's true. Or just begin hearing witness testimony. That's true. The state never explained that there was a third option, the most critical option of all under the governing law. The grand jury could consider the alert letter, hear witnesses the prosecution identified, and direct that the witness testimony and documentary evidence identified in the alert letter be presented. They were told this. They just didn't want to hear it. They didn't want to hear from those witnesses or documentary evidence. It was all made available to them. After returning from a short break, the grand jurors asked about a few typos in the letter, making clear that the grand jurors had no idea what New Mexico law required them to consider about the alert letter. I don't know what typos has to do with anything. After discussing the typos, Morrissey stated that she can't fix the typos on the grand jury evidence alert letter because it's not ours. Fair enough, it's a defense letter. Again, conveying the impression that reading the letter was merely a formality before she commenced the actual hearing of evidence she wanted to present. Morrissey then asked the grand jury, do you have any other questions? Anybody else have any other questions? You want to tell us how you want to proceed? This is all perfectly appropriate. In response, the grand jury foreman stated, I think if that's the end of questions about the letters and warrant letters, we'd probably proceed with witnesses if that's okay. Again, demonstrating the grand jury's failure to understand the basic purpose of the alert letter or their right and obligation to exercise independent control over the evidence that was presented. They exercised independent control over the evidence that was presented. They looked at the evidence that they wanted to look at. All the evidence was made available to them. Second, Special Prosecutor Morrissey diverted the grand jury from hearing exculpatory evidence, as well as other evidence that would be helpful to Baldwin, by refusing to facilitate the grand jury's repeated inquiries into the witnesses and documents identified in Baldwin's alert letter. Instead of giving grand jurors the information they requested from the witness best able to provide it, Morrissey would redirect such inquiries to her own witnesses and further cement the notion that these were the only witnesses the grand jury had access to. Further cement the notion is nonsense speak. That's just frilly language in the She's not cementing anything. This is not literal. This is figurative. Again, the grand jury was given the alert letter, read it to them, the witnesses in it. They were told they could subpoena any of them. And the box of documentary evidence was present for them to look at in the room, and they knew it. For example, at one point during Investigator Hancock's testimony, a grand jury asked, so the bottom line is the responsibility of making sure these guns, these bullets are not live, are up to what, David Halls and Hannah? The truthful answer to that question is yes. But rather than ask the grand jurors if they wanted to hear from Halls directly or inform them that this was an option, Morrissey responded, we are going to have another witness address those issues for you. We have an expert who works on movie sets, and he's going to answer those questions for you, if that's okay. The witness she was referring to was Brian Carpenter, the state's paid expert, whose false answer to that question, blaming the situation on Baldwin, would have been refuted by Halls, the relevant industry safety bulletin, and SAG. Well, this is all untrue. I covered this in yesterday's show. Baldwin had an equal right to have in front of him the gun shown to not have live rounds in it, as much as anybody else on that set. Arguably more so, since he's the person who would be handling and pointing the gun. Notably, at the trial of Hannah Gutierrez, one of the jurors had publicly stated that the jury's verdict was based on the fact that it was Gutierrez's job to check those rounds and those firearms. Even Morrissey agreed with that view at Gutierrez's trial, contradicting the false testimony she elicited for the grand jury. In summation of trial, Morrissey argued that Gutierrez is the autonomous decision maker with regard to gun safety, and that Gutierrez was responsible for Hutchins' death because it was foreseeable that Baldwin would not check the gun. Okay, lots of people can be responsible for the death of Halyna Hutchins. Hannah Gutierrez was appropriately convicted of involuntary manslaughter for allowing live rounds on set and handing a gun onto the set that had a live round in it. That doesn't relieve Alec Baldwin from liability for pointing what he knew to be a real gun at another human being, cocking the hammer, pressing the trigger, without first ensuring there was no live ammo in the gun. Now, he didn't have a legal duty to clear the gun per se, but he had a legal duty not to create an unjustified risk of death to another person, which is what he did when he pointed the gun at Halyna Hutchins, cocked the hammer, pressed the trigger without ensuring the gun wasn't loaded. If he had not pointed the gun at Halyna Hutchins, a live round in the gun is no big deal. The bullet goes off into the wild. If he had not cocked the hammer and pressed the trigger, a live bullet in the gun is no big deal. The gun never fires. There's lots of ways that Alec Baldwin could not have committed involuntary manslaughter. He just chose the combination that led to involuntary manslaughter. Continuing now. When another grand jury asked, shouldn't somebody have seen the difference before it went into the gun? Morrissey again deflected the question away from Halls, because the relevant legal question here has nothing to do with Halls, has nothing to do with who put the live round in the gun. Indeed, New Mexico case law on involuntary manslaughter with the gun doesn't care who loaded the gun, when it was loaded, how it was loaded. That's completely irrelevant. All that matters is it happens there was a live round in the gun when the person handling the gun did so without due care and circumspection. I have a little bit of case law here on that right here. New Mexico Supreme Court, quote, it could have made no difference to the trial of a charge of involuntary manslaughter as to who loaded the gun. All that is necessary to establish for involuntary manslaughter by the use of a loaded weapon is that a defendant had in his hands a gun which at some time had been loaded, and that he handled it without due caution and circumspection, and that death resulted. Close quote. That is Alec Baldwin's conduct to a T. So Morrissey again deflected the question away from Halls, who previously testified that he should have checked the gun before handling it to Baldwin. Instead, she stated, like I said, we're going to have more testimony on this that hopefully will help with that. Help show you that Halls is irrelevant to Baldwin's prosecution. At no point did Morrissey explain to grand jurors that they could hear from Halls directly if they wanted to. Well, that's just not true. Morrissey later introduced testimony that Baldwin could have determined the difference between a dummy and a blank without any basis for that testimony, and contrary to what at least one other person on the set told the Santa Fe Sheriff's Office. Well, Baldwin, when interviewed by investigators the day of the event, made clear he demonstrated to them that he knew the difference between a real round and a blank. So he could have determined the difference between a real round and a blank and a dummy. Continuing, on another occasion, a grand juror asked, when Alec Baldwin refused to look at the gun that was handed, that was allegedly cleared, and they gave it to him to reinspect it, how would he inspect the gun? Would he take all the bullets out into his hand and start shaking them, or would he just open the chamber and look at the top, make sure it was kind of seated all the same and no inconsistencies? The question itself is troubling because it reflects at least three material misunderstandings. One, that Baldwin refused to look at the gun, legally irrelevant to the manslaughter charge, that he was required to reinspect it once it was handed to him, legally irrelevant to the manslaughter charge, and three, that there is a protocol for actors on how to check weapons. Well, there actually is. They would ask the armorer to empty the gun in front of them, demonstrate that each round was a dummy or a blank, and then reload the gun right in front of them. These misunderstandings are the direct result of false testimony from Morrissey's witnesses, and Morrissey had a duty to elicit truthful evidence to rebut them. For example, had the grand jury been able to question Halls, well, they were able to, or been referred to affidavits about the incident, affidavits with irrelevant content, the correct safety bulletin, the safety bulletin says gun safety is everybody's responsibility, including the actor, and the actor should never point the gun at another person or put his finger on the trigger if he doesn't want the gun to fire. That's what the safety bulletin says. Or SAG's official views, they're talking about a press release released earlier this year after the Baldwin was reindicted. And in the press release, they say, well, it wasn't really Alec's fault. Actors are not gun experts. Pure PR propaganda. But had they seen that, the grand jury would have understood that Baldwin didn't refuse to check or reinspect the gun. Rather, he had no obligation to check it in the first place, and therefore was never asked or told to check the gun or given a protocol for doing so. Again, irrelevant. It doesn't matter if there's a live round in the gun. It doesn't even matter if it goes off. If the muzzle is not pointed at Halyna Hutchins, who pointed the muzzle at Halyna Hutchins? Alec Baldwin. But Morrissey diverted the inquiry, stating, is it okay with you if we address that question to a different witness? Again, she was referring to Brian Carpenter, a movie set armorer expert witness, whose false testimony would compound the grand jury's misunderstandings. Not false. That's a mischaracterization by the defense. In fact, Carpenter testified at Gutierrez's trial that Gutierrez and Halls, not the actor, have the obligation to check and clear the gun, which is the opposite of what he falsely told the Baldwin grand jury. This is supposed to be the lie. Carpenter testifying at trial that actors can check the gun if they want to. However, those safety checks are more for a warm and fuzzy feeling for them, and that's rare. But that means they can do it. They're allowed. Carpenter, you clear that weapon with at least 2 representatives on set. Anybody that wants to see it. Anybody that wants to see it. It gets cleared with them if they request. But generally, it's going to be your first assistant director and possibly the director of photography as well. Morrissey asked, are you testifying that you show the individual dummy rounds to the assistant director and whoever else wants to see them? Carpenter, absolutely. Morrissey, and the actor? Carpenter, the actor may or may not be on set yet, but when they get there, this is done again. So with the actor, and sometimes you'll have an actor that says, nah, I don't want to see it, and they'll just brush it off. But as long as you've done your safety check with at least 2 other sources and moved through that process, then you've done what you should have done. Morrissey, and whose responsibility is it to ferret out any possible live rounds on a movie set? Carpenter, it's the armorer's responsibility. But again, it doesn't matter here because Alec Baldwin committed other reckless acts, pointing the gun at Halyna Hutchins, cocking the hammer, pressing the trigger. Morrissey did not present that critical exculpatory evidence to the grand jury. It's not exculpatory on the elements of involuntary manslaughter on the facts of this case. And she was so determined to keep Halls out of the picture that she cut off her own witnesses if their testimony focused on issues where Hall's statement or conduct would exculpate Baldwin. There's literally nothing Halls can say that would exculpate Baldwin. Nothing. So his testimony is irrelevant. Because nothing Halls can say changes the legal question, which is this. Morrissey also steered grand jurors away from other critical witnesses identified in Baldwin's alert letter. Well, that's okay if the witnesses don't have any relevant exculpatory evidence to offer. While Rice, Morrissey's paid investigator, was testifying, a jury made a direct inquiry about Sarah Zachary's responsibility. In response, Morrissey indicated that Rice may not be familiar enough with the relationship between the prop master and the armorer to answer that question, but we have a witness sitting out there who may be able to answer it. The witness, according to the defense, should have been Zachary, who made exculpatory statements on this topic. No, not exculpatory. Helpful to the defense, smoke and mirrors for the defense, but it doesn't have anything to do with the actual elements of the criminal charge here. Instead, it was Lane Looper, who Morrissey offered to bring back. Lane Looper was a photographer on the set who quit the day of the fatal shooting, the morning of the fatal shooting. Instead, it was Lane Looper who Morrissey offered to bring back to answer the grand jury's questions about Zachary's role. When the same grand juror asked on even more specific questions about Zachary, Morrissey redirected the question to Rice, their investigator, and then peppered Rice with questions about Zachary that Zachary herself was in the best position to answer and that Rice had no foundation to answer. At no point during this exchange did Morrissey explain that Zachary herself was available to testify. Well, not during this exchange, but earlier, Morrissey had said, here's the alert letter. Sarah Zachary is one of the listed witnesses. You can subpoena any of these people if you'd like to hear them testify. At no point during this exchange did Morrissey explain that Zachary herself was available to testify, that other witnesses who had communicated with Zachary about this issue could testify, just hearsay, that Morrissey was obligated to present these witnesses if the grand jury wished to hear from them, or that the grand jury had an obligation to request evidence that might be exculpatory or favorable to Baldwin. No, only if it's relevant, meaning it tends to negate one of the criminal elements, which none of these witnesses can do. As a result of Morrissey's diversions, the grand jury never heard from the film's director, Joel Souza, its producer, Ryan Smith, its first assistant director, David Halls, or its prop master, Sarah Zachary, even though each of these witnesses had exculpatory testimony that would have satisfied the grand jury's inquiries in ways that Morrissey's paid and attenuated witnesses could not. Again, this is just the defense falsely characterizing Baldwin favorable evidence. We like Alec Baldwin. We don't think he did anything wrong as exculpatory testimony. It has to be relevant exculpatory testimony, which none of these witnesses can do. But rather than facilitate the grand jury's inquiry into Baldwin's irrelevant witnesses, Morrissey also withheld over a dozen exculpatory documents that were relevant to the grand jury's inquiries and contained specific answers to many of their questions. It doesn't matter if the questions were not relevant. It doesn't matter if the supposedly exculpatory documents are not relevant to the criminal charge, not whether they're relevant to the grand jury's inquiries. The grand jury's inquiries could be irrelevant to the criminal charge, and so the inquiries themselves are irrelevant. So any evidence as to irrelevant inquiries would be irrelevant. Section C, the special prosecutors issue an improper prejudicial instruction to the grand jury. Morrissey supercharged these failures. Again, that's just figurative, hysterical language. Morrissey supercharged these failures by issuing an improper instruction on a critical element of the charging statute. Specifically, on 3 separate occasions, Morrissey instructed the grand jury that to return a true bill, an indictment, it must find probable cause as to each of the following elements. 1, the target, Baldwin, discharged the firearm during the production of the movie without first verifying the firearm contained no live ammunition and while the firearm was pointed in the direction of another. Well, both of these are true statements. Baldwin has a legal duty to handle that gun with due care and circumspection. These are just ways that he failed to do that. 2, the target should have known the danger involved from the target's actions while he knew he was handling a real gun that could fire real bullets. And 3, the target acted with a willful disregard for the safety of others. That really goes back to part 1, no due care and circumspection. And the target's act caused the death of Halyna Hutchins. That's indisputable. Morrissey included the italicized language even though she had successfully argued to the court that Baldwin's requested instruction concerning subjective knowledge was improper because it assumes that the factual basis of a negligent act was failing to check the firearm for live rounds, and that any deviation from the UGI, the Uniform Jury Instructions, by inserting such language was unwarranted. Well, so the defense had asked that to be a required element of manslaughter. that Baldwin had to have a subjective knowledge that there was a live round in the gun. That's not an element of manslaughter under New Mexico law. What's required for manslaughter is that you were engaged in an act that you knew could cause death, handling a real gun, and you didn't do so with due care and circumspection. The italicized language is just the prosecutor pointing out to the jury what the state is claiming to be the lack of due care and circumspection. It's not an element of the crime, per se, that he didn't verify the firearm was loaded. The element of the crime is lack of due care and circumspection. These are the facts of that lack of due care and circumspection in this case. And you're allowed to customize standard jury instructions for the facts of this case. The courts don't like it when you change the legal aspects of the jury instruction, but you're allowed to kind of do an ad libs, fill in the blank with like the parties' names, the defendant's name, the victim's name, the specific facts that are relevant to a claimed element. The instruction Morrissey gave to the grand jury deviates from the uniform jury instruction and violates the court's order. Nah. The court's order was to use the uniform jury instruction, but the way Morrissey did that here is totally normal and permissible. It also places an affirmative duty on Baldwin to check the gun for live bullets, and therefore obtain subjective knowledge about the very thing that Morrissey told the grand jury court has nothing to do with the ways in which the state intends to prove Baldwin's negligence. Now, these are two separate things. Whether Baldwin had a specific affirmative duty to check for live bullets, that's one way he could violate due care and circumspection. But the other ways he could violate due care and circumspection was to point the muzzle at Halyna Hutchins and also to cock the hammer and press the trigger, which is part of this italicized statement, right? While the firearm was pointed in the direction of another. So this is just some sleight of hand by the defense here, and which the state's expert at Gutierrez trial, Carpenter, testified was not the actor's responsibility. Safety is everyone's responsibility. Continuing, on January 19th, 2024, the grand jury returned an indictment. The indictment states that it is based upon the testimony of Alexandra Hancock, Brian Carpenter, Lane Looper, Ross Adiago, Michael Haig, Marissa Popple, and Connor Rice. The grand jury did not receive the favorable or exculpatory testimony and documents that the state had an obligation to present. No, the state doesn't have an obligation to present anything the defense offers. The state has an obligation to make available for presentation what the defense includes in their alert letter. Then it's up to the grand jury. Nor was the grand jury told it had the right to review and the obligation to request this information. It doesn't have an obligation to request the information. The information is presented to be available to the grand jury, and it's at the grand jury's discretion who they want to hear from. They do have an obligation to hear actually relevant exculpatory information, but nothing the defense was offering qualified as that. All right, continuing. Argument 1. The state's intentional withholding of exculpatory evidence subjects the indictment to judicial review. Well, all that means is the court has the authority to review the indictment, which would be the case anyway. A court may review the sufficiency of the evidence underlying an indictment upon a showing of prosecutorial bad faith. The best way to give effect to this purpose is by giving the phrase bad faith its ordinary meaning: dishonesty of belief, purpose, of motive. So they're explicitly accusing Special Prosecutor Kari Morrissey, whose reputation in New Mexico legal services circles is pristine. They're accusing her of dishonesty of belief, purpose, or motive. The state's conduct throughout the grand jury process demonstrates its dishonest belief, purpose, or motive, and therefore subjects the indictment to judicial review. From the moment this prosecution began, Morrissey has sought to prejudice Baldwin. Well, you're indicting someone for manslaughter. Of course, that's prejudicial to them. Everything the state does is prejudicial to Baldwin. That doesn't make it inappropriate. They're trying to put him in prison for manslaughter. The list of misconduct leading up to the grand jury proceeding is both long and disturbing. Morrissey publicly announced her decision to pursue an indictment in violation of the rules governing the grand jury process. As we'll see in Morrissey's response, that's nonsense. Morrissey made public statements commenting on Baldwin's purported guilt in violation of the rules governing prosecutors' statements to the press. Well, she did this in response to defense statements like the Baldwin interview by George Stephanopoulos. She's allowed to respond to defense statements to the media. Morrissey sent Baldwin a target notice that violated New Mexico law by excluding the 48-hour deadline. Well, and that grand jury hearing was pushed back by the court by more than 2 months. So no harm from this. Morrissey filed an unprecedented motion to conduct a one-sided voir dire of the grand jury. But this never happened. So again, no harm from this. Morrissey twice violated the court's order to refrain from disclosing information about the grand jury hearings to the public. Well, again, this was in response to the defense speaking to the media. Morrissey rejected almost the entirety of Baldwin's alert letter by seeking to preclude nearly all of Baldwin's exculpatory and favorable evidence. Again, the evidence has to be relevant, meaning the evidence tends to negate one of the elements of the criminal charge, which none of this did, or it raises a legal defense, which none of this did. The defense is entitled to have relevant exculpatory evidence put in front of the grand jury, not anything they call exculpatory. Let's see. Morrissey refused to contact nearly all of the witnesses that Baldwin identified in the alert letter. Well, it's not her job to contact them. She can tell the grand jury that they have the power to subpoena those witnesses. They were made aware of that power and the witnesses. Despite the court's order that she make the witnesses available for the grand jury. Well, she made them available to the grand jury. Morrissey told the media that the state was motivated to pursue this prosecution to humble Baldwin because the special prosecutors find him arrogant and want to give him a teachable moment. There's literally zero direct evidence of this. This is reporting by news media reporting about an unnamed source that supposedly heard Morrissey say this. The grand jury term was set to expire just 1 day after Morrissey intended to begin her presentation of the case, yet Morrissey refused to adjourn the grand jury date to ensure she had adequate time to present all exculpatory evidence and witnesses. Again, her obligation is to present relevant exculpatory evidence and witnesses. Everything the defense was offering was not relevant. So it's not required to be presented. So she didn't need time to present irrelevant exculpatory evidence and witnesses. She had plenty of time to present what she was required to present and did present. It was clear from Morrissey's questions to the grand jury court that she knew she could not present all the necessary evidence in that short time frame. Well, she could present all the necessary relevant evidence, which is what matters. All of this misconduct occurred on the heels of the state's initial prosecution, a bad faith debacle in which the prior prosecutors resigned after violating U.S. and New Mexico constitutions, New Mexico law, and the ethical rules governing prosecutors. Let's pretend that's all true. That's got nothing to do with this prosecutor. Those prosecutors resigned. Their grand jury indictment was dismissed. The slate was wiped clean. Everything started fresh with Kari Morrissey and a new grand jury. So none of that matters to this indictment. Continuing. Morrissey doubled down on this extraordinary misconduct by violating the standards governing her presentation to the grand jury. The court rejected nearly every argument the state presented leading up to the grand jury proceeding and explained the legal standards that govern the presentation of evidence to a grand jury. So if the court rejected it, it didn't happen. So no harm. As described in detail above, however, the state violated those standards over and over. Nope, that's not what happened. Morrissey ensured that the grand jury had no understanding of its obligation to request exculpatory and relevant evidence or the purpose of Baldwin's alert letter. She read them the alert letter. The alert letter could have said in the letter, this is the purpose of this letter. That's up to the defense. And look at the phrasing. Obligation to request exculpatory and relevant evidence. As if exculpatory and relevant were two different things, alternatives. Properly written, this would read, the obligation to request relevant exculpatory evidence. There is none offered by the defense to the actual criminal charge. Morrissey then excluded all of the exculpatory and favorable evidence. She has no obligation to offer favorable evidence. Favorable evidence is like Alec Baldwin's mother coming into the grand jury and saying, my son's a good boy. He would never mean to hurt anybody. You'd like him if you met him. That's favorable evidence. It's just not relevant to the criminal charge. The witnesses who would have given favorable testimony about Baldwin, again, it doesn't matter if it's not relevant favorable testimony, were kept from the grand jury. Every favorable or exculpatory document was concealed or only partially presented. Again, it doesn't matter if they were irrelevant to the criminal charge. Every favorable fact was hidden. Only matters if it's a fact relevant to the criminal charge. And all of the grand jury's inquiries about exculpatory information were redirected to witnesses who misrepresented the facts or had no foundation for giving the answers. The exculpatory information only matters if it's relevant to the criminal charge. The state had one goal. Yeah, they had one goal. Indict Baldwin, no matter the truth. What? No matter the rules or court rulings, and no matter what it took to do so. If the state's conduct here does not demonstrate the level of bad faith necessary to subject an indictment to judicial review, it is all but impossible to imagine a set of facts that would. This is all just theater talk. 2, the indictment must be dismissed. Under New Mexico law, the grand jury is our system's foundation for the protection of individual rights and a recognized method by which the public can be certain of protection against abuse of public responsibilities. But the grand jury method cannot function when prosecutors conflate their role as an aid to the grand jury with the role of the grand jury itself. I'm going to skip all the internal little paragraph quotes here. That is exactly what happened here. The state deprived the grand jury of its ability to accurately and independently assess the government's evidence of probable cause and instead used the grand jury as a private tool to obtain Baldwin's indictment. The grand jury had everything they needed. Everything that the defense offered. They could have subpoenaed every witness. They could have gone through the box of supposedly exculpatory evidence. It was all given to them and pointed out to them what this was. The indictment must be dismissed for 2 independent reasons. First, the state unlawfully deprived the grand jury of critical evidence. Notice it doesn't say relevant evidence. Critical evidence that disproves the charges or makes an indictment unjustified. See, they combine these two. See the trick here? It's wrong if it either disproves the charges or makes an indictment unjustified. Disproves the charges would mean it negates one of the elements. None of this evidence does that. But does it make an indictment unjustified? Well, unjustified is just a subjective judgment call, right? The defense thinks it's unjustified. And second, the state conducted the grand jury process in an unlawful manner, including by providing an improper charging instruction regarding a critical element of the offense. Nah, that's not what happened. We just went over that. A, the state unlawfully deprived the grand jury of exculpatory evidence. They always leave out relevant. Exculpatory evidence and evidence that was favorable to Baldwin's position. Again, that's like bringing in Alex's mother. Continuing, unless the grand jury is empowered to consider all lawful, relevant, and competent evidence bearing on the issue of probable cause, the grand jury cannot perform its historical role of determining whether those accused of wrongdoing by the government should suffer the burdens of a criminal prosecution. Thus, the state was required to facilitate the grand jury's inquiry into any lawful, relevant. Notice every time the defense is quoting actual case law, what does the case law say? Does it say lawful, competent evidence? Does it say lawful, favorable evidence? Does it say exculpatory, favorable evidence? Or does it always include the word relevant? Thus, the state was required to, quote, facilitate the grand jury's inquiry into any lawful, relevant, and competent evidence not initially presented by the state that would disprove or reduce the charges. That's what I've been saying, right? Disprove or reduce the charges. It would tend to negate one of the elements of the criminal charge. That's what makes it relevant. That would disprove or reduce the charges against Baldwin or make an indictment unjustified. Morrissey's intentional violation of that duty, no, and withholding of potentially exculpatory evidence strikes at the very heart of the grand jury's assessment of probable cause to indict. The indictment must be dismissed because the state withheld exculpatory and favorable evidence. What's missing here? The word relevant. As described above, excuse me, folks. As described above, Baldwin's alert letter describes piles of documents and more than a half dozen witnesses who had information favorable to his defense. Missing again is the word relevant. There are witnesses who saw Baldwin's conduct in set, and it said he handled guns safely. Was he handling it safely when he killed Halyna Hutchins? Because that's the only relevant question here. A witness who said that he, not Baldwin, was responsible for checking the firearm and that Baldwin was not at fault. That would be David Halls. What does he have to do with Baldwin pointing the gun at Halyna Hutchins, cocking the hammer, and pressing the trigger? There are documents corroborating Baldwin's statements that he had no control over the production of the movie, other than the right to give limited creative input about co-stars and script. Baldwin's role as a producer is irrelevant to this manslaughter charge. He's not being charged under some kind of agency principle where it was not him, it was some other actor handling the gun, but he's nevertheless criminally responsible because he had authority on the set. That's not why he's being prosecuted. So it doesn't matter what his role as a producer was. If anything, it makes things worse for him because he was the guy with ultimate authority on the set. No one was going to question if he wanted the gun checked for live rounds in front of him. So it certainly doesn't help him, but that's not an element of the criminal charge against him. So again, it's irrelevant. Guidelines and industry statements that made clear Baldwin had no obligation to check the gun. Industry statements is that press release by SAG. All their existing safety rules prior to the shooting put the responsibility for safety on everybody, including and explicitly the actor. There are also documents and testimony showing that the set was safe. Well, see how vague this is? How passive voice, the set was safe. That's not the legal question, is it? The legal question is, was Alec Baldwin safe, acting with due care and circumspection when he pointed that gun at Halyna Hutchins, cocked the hammer, pressed the trigger, fired a live round, and killed her? The list of favorable evidence goes on and on and on. But is it relevant favorable evidence? That's the legal question. For example, Director Joel Souza was standing behind Hutchins when the gun went off and was struck by the same bullet that killed Hutchins. His statements to law enforcement following the incident support Baldwin's case. All his statements are irrelevant to the criminal charge. Similarly, First Assistant Director Halls is the only witness, other than Gutierrez, with firsthand knowledge of the condition of the gun before it was given to Baldwin. Irrelevant to the criminal charge. He's also the only person, other than Gutierrez, who was required to inspect the gun before it was handed to Baldwin, and he admitted that he failed to properly do so. Multiple people can share responsibility for this tragic shooting. Morrissey was required to elicit this exculpatory testimony from Halls and Souza. No, because it's irrelevant to the criminal charge. She was also required to provide the grand jury with specific documents identified in Baldwin's alert letter that reflect these and similar exculpatory statements from both witnesses. What's missing from this sentence? Relevant exculpatory statements. For example, in the same interview where Halls told the state that he failed to properly inspect the gun before it was handed to Baldwin, he told the state that he feels some culpability for Hutchins' death, since he, not Baldwin, was the last line of defense when it came to the inspection of firearms on set. Well, that's just not a true statement by Halls, even if he believes it to be true. Any actor can ask that the real gun being put in his hand be shown to him to not have live rounds, especially an actor who has the most authority on the set. Halls also said he didn't think Baldwin should be criminally prosecuted. What does that have to do with anything? The first assistant director feels that the person who shot and killed Halyna Hutchins shouldn't be held criminally prosecuted? What does his opinion have to do with anything? Sarah Zachary, the film's prop master, supervised Gutierrez and is the only person who claimed to have witnessed Gutierrez load the gun before it was brought into the church. So what? Immediately after the accident, Zachary told Detective Joel Cano that based on what she witnessed, she believed Gutierrez might have messed up by shaking 2 rounds at once while checking for dummy rounds as she loaded the gun. How did that make Alec Baldwin point the gun at Halyna Hutchins, cock the hammer, and press the trigger? It's irrelevant. The grand jurors needed to hear these facts from Zachary, and they repeatedly asked about her. But Morrissey prevented that from happening, instead calling back witnesses who had no personal knowledge about the grand jury's inquiries. Well, the inquiries are only relevant if they go to a relevant issue, which these were not. Zachary's testimony likely would have established that Gutierrez was an intervening cause in the chain of events that led to Hutchins' death, yet Morrissey concealed that evidence from the grand jury. No, there can be no intervening cause here. So an intervening cause is something that intervenes between a person's claimed bad act and the bad outcome. So an intervening cause might have been that Alec Baldwin didn't check the gun for live rounds, but he was carefully pointing the muzzle away from any person when he cocked the hammer and pressed the trigger. But then as he's pressing the trigger, the bad act, a piece of the set falls on him and changes the direction of the muzzle so that it points at Halyna Hutchins, and Halyna Hutchins is shot and hit by that round and killed. That would have been an intervening cause between Baldwin's conduct and the bad outcome. But intervening conduct happens between the bad act and the outcome, not before. Not before. There was no intervening cause that compelled Baldwin to point the muzzle at Halyna Hutchins, cock the hammer, and press the trigger. Same song, different verse for Baldwin's other witnesses. Morrissey did not facilitate the grand jury's access to them, even when the grand jury's inquiries implicated important aspects of their expertise, previous testimony, or roles on the set. All of this only matters if it was relevant issues or questions. For example, Morrissey knew that Ryan Smith, one of the film's producers, would have contradicted testimony by several of Morrissey's witnesses that Baldwin was in charge as the producer. Again, this is irrelevant to the criminal charge here. As Smith would have testified, Baldwin's role as a producer was limited to making creative decisions, and Baldwin was not responsible for hiring crew members, enforcing safety protocols, setting the budget, or managing day-to-day operations, contrary to the false testimony from Morrissey's witnesses. Again, that Baldwin was a producer. Any actor holding that gun, the least authoritative actor on that set who did what Baldwin did, would have committed involuntary manslaughter. Authority on the set doesn't change that. The OSHA report, another piece of evidence the state failed to present to the grand jury, corroborates this account. Well, the OSHA report only looks at institutional responsibility of the Rust production. It does not even consider individual responsibility, so it is irrelevant to the individual responsibility of Baldwin for involuntary manslaughter. Nor did Morrissey facilitate the grand jury's access to Robert Schilling, a former investigator involved in the case, who described the state's investigation as reprehensible and unprofessional to a degree I still have no words for. Well, it's true. The state, the investigators, the police, did a sloppy job on many aspects of this case. But none of the slop is material or relevant to the criminal charge against Baldwin. For example, they picked up the Baldwin gun afterwards without wearing gloves. So they could have added fingerprints or smudged fingerprints or added DNA or removed DNA. Sloppy. They're supposed to wear gloves when they pick up evidence. But none of that is material here because it's not disputed that the gun was in Baldwin's hand when the shot was fired. So it's all irrelevant. Morrissey did not make any of these witnesses available to the grand jury or even inform the grand jury that they were available. She's not obligated to inform the grand jury of irrelevant witnesses. She did not present the exculpatory or favorable evidence described in more detail later. What's missing from this sentence? The word relevant. She's only required to present relevant exculpatory or favorable evidence, meaning relevant to the elements of the criminal charge. And she punted the grand jury's inquiries to the state's hand-picked witnesses whose testimony was biased, inaccurate, and in most cases, flat out untrue. So most of the witnesses were giving false testimony? Again, it doesn't matter unless the false testimony was on a relevant issue. If the state had conducted the grand jury process consistent with New Mexico law, the outcome should and almost certainly would have been different. In short, the state concealed substantial exculpatory and favorable evidence from the grand jury. What's missing from that sentence? It's like the defense doesn't know what the word relevant exists. The court should therefore dismiss the indictment. B, the state manipulated the grand jury process and gave an improper jury instruction in violation of the court's order and New Mexico law. The state's bad faith withholding of exculpatory evidence alone requires dismissal. Moreover, in such cases, the target is entitled to dismissal of the indictment and is not required to demonstrate prejudice. The indictment should be dismissed on this separate basis. New Mexico law provides structural protections that safeguard the grand jury's ability to perform its constitutional function. If the prosecutor does not strictly adhere to the grand jury statutes and procedural rules designed to protect the target's rights and ensure the fundamental fairness of the proceeding, the structural integrity of the grand jury process is compromised, along with the grand jury's determination of probable cause. Thus, to preserve the integrity and independence of the grand jury process, prosecutors must conduct themselves in a fair and impartial manner at all times when assisting the grand jury. Okay, fair enough? The smallest prosecutorial error can have severe consequences for a target. Therefore, New Mexico courts recognize that the target's right to a fair and lawful process should be rigorously protected. Okay? From day one, however, the state violated these obligations. For example, the state provided an inaccurate jury instruction regarding a critical element of the charged offense. This is the third time this motion is referencing this. We've talked about it twice already. The state instructed the grand jury that it must decide whether there was probable cause to support the allegation that Baldwin discharged a firearm during the production of the movie without first verifying the firearm contained no live ammunition and while the firearm was pointed in the direction of another. What's wrong with that? That's just a factual description of the absence of due care and circumspection that the New Mexico involuntary manslaughter statute requires. Jury instructions are not to be changed in a legal sense, changing the law of the instruction. They are allowed to be contextualized with the facts of the particular case. So in a murder jury instruction, the instruction might say somebody intentionally killed the victim with a deadly weapon. And the jury instruction read to the grand jury might say, we're arguing that this defendant killed the victim with a deadly weapon, a gun. Is that changing the jury instruction? Yes, but in a permissible factual way, not a legal way. Morrissey effectively instructed the grand jury that Baldwin had a duty to check the firearm for live ammunition. This is just the defense preferred interpretation. And to refrain from pointing the gun at anyone. Well, he did have a legal duty to not point the gun at anyone. He had a legal duty to handle what he knew to be a real gun with due care and circumspection. That's the statutory language. Contrary to her prior arguments to the court and without any support from the uniform jury instructions or New Mexico law. In fact, this instruction violated the grand jury's court order, which rejected previous attempts by the parties to provide any instructions that were materially different from the uniform jury instructions. But this is not materially different. Materially different would be a change in the law of the instruction, not a contextualization of the facts of this case to which the instructions are being applied. The defense had previously tried to make a material change to the jury instructions by saying that they wanted the jury instruction to read, you can't indict or convict Alec Baldwin unless the state proves he knew for a fact that there was live ammo in the gun. Well, if he knew for a fact there was live ammo in the gun, this would be a murder prosecution, not a manslaughter prosecution. For manslaughter, it's enough that he knew there could have been live ammo in the gun and didn't act with due care and circumspection to make sure there wasn't. Morrissey's refusal to prevent Dave Hall's testimony to the grand jury, I don't think Alec did anything wrong, compounded the impropriety of this instruction because Halls would have testified unequivocally that it is not the actor's duty to check whether a prop gun has been loaded with live rounds or to refrain from pointing it at the camera after being told it was safe to do so. Is Alec Baldwin being prosecuted for manslaughter because he killed the camera? It's not that he pointed it at the camera. It's that he pointed it at Halyna Hutchins. Both the applicable industry safety bulletin and SAG's public statements also confirm this fact. Well, the first half of that sentence is a lie. The safety bulletin, in effect at the time, made safety with firearms the responsibility of the actor holding the firearm. And SAG's public statement is just a propaganda press release after the fact, earlier this year. And Morrissey's own expert, Brian Carpenter, testified at Gutierrez trial that Gutierrez and Halls, not the actor, have the obligation to check and clear the gun. Even if that were true under movie set standards, it's not true under New Mexico criminal law, and New Mexico criminal law trumps movie standards. Movie practices are not superior to state criminal law. Let's see. I'm trying to get past all this parenthetical stuff. Carpenter also acknowledged that the actor had no obligation to even watch the gun be cleared. All that's fine, as long as the actor is otherwise acting with due care and circumspection. Yet Morrissey never presented any of that evidence to the grand jury and read an instruction to the grand jury that improperly imposed this non-existent obligation. Again, the statutory obligation is to act with due care and circumspection. Precisely what is needed to be done in any particular case to satisfy that requirement will vary depending on the circumstances. And then they become the due care and circumspection that is the duty of the person handling the gun. The statute doesn't have to say the actor had to check the gun for live ammo. It's dependent what qualifies as due care or circumspection or a failure of that. That's a generalized concept. What's specifically required to meet that legal duty obviously varies with the particular case. Yet Morrissey never presented any of that evidence to the grand jury and read an instruction to the grand jury that improperly imposed this non-existent obligation. Nope. Morrissey's inaccurate jury instruction is an independent cause for dismissal. No. Continuing, the state knowingly failed to advise the grand jury of its authority. A grand jury may order, up to them, that evidence be produced over and above that initially presented by the state. That's true. And has a duty to weigh all the evidence submitted to it, and when it has reason to believe that other lawful, competent, and relevant evidence is available that would disprove or reduce a charge that would tend to negate one of the criminal elements of the charge, meaning evidence that doesn't do that is irrelevant and need not be considered by the grand jury. Whoops. To reduce a charge or accusation, or that would make an indictment unjustified, then it shall order the evidence produced. But that requires relevant evidence. That applies to relevant evidence. Morrissey communicated the exact opposite message to the grand jury. For example, Morrissey never explained the meaning or practical significance of Baldwin's alert letter, why it was being read into the record, or what the grand jurors were supposed to do with it. You know what could have said all of that? The alert letter could have said, it's the practical significance of this letter. It's being read to you because, and this is what you're supposed to do with it. Who wrote that alert letter? The defense. They could have included all that, and Morrissey would have read that verbatim to the grand jury. Nor did Morrissey explain that the witnesses identified in the alert letter were available to testify. She told the grand jury they had the power to subpoena any of those witnesses. Instead, she conveyed that the grand jury would hear from only her selection. Conveyed. This is just hand-waving. Figurative language. Instead, she conveyed that the grand jury would hear from only her selection of witnesses, telling the grand jury only 1 minute into the proceeding that the witnesses in this case will be Corporal Alexander Hancock, Marissa Popple, etc., all the state witnesses. She also told the grand jury they could subpoena anybody they wanted. Morrissey then doubled, and a bunch of those names were listed in the alert letter she read to the grand jury. Morrissey then doubled down by directing the grand jury's inquiries about exculpatory evidence, again, they leave out the word relevant, to one of her 7 witnesses, whom she narrowly questioned and even cut off mid-testimony to ensure they didn't disclose any irrelevant information that was favorable to Baldwin's position. In these important moments, Morrissey made sure that none of the grand jurors understood that they may order that evidence be produced over and above that initially presented by the state. Look how they phrase this. She did actually tell the grand jury this, but maybe she didn't say it in these important moments. She didn't say it at the timing the defense would have liked, let alone that they were required to do so. They're only required to look at relevant evidence. Therefore, Morrissey interfered with the grand jury's fact-finding function. They don't have a duty to find irrelevant facts in a way that threatened the structural integrity of the grand jury process by undermining the grand jury's ability to accurately and independently assess the government's evidence of probable cause. The state's grand jury process was structurally flawed from start to finish. The structural integrity of the process has also been destroyed by the cumulative impact of the state's misconduct. From the moment this prosecution began, Morrissey has sought to undermine Baldwin's rights and eliminate the possibility of a fair playing field. She improperly disclosed confidential grand jury information to the public, including the existence and date of the grand jury, Again, this was all in response to the defense statements to the media. The prosecution's allowed to respond to that. Then she tried to jam through an indictment in a 3-week period while simultaneously trying to limit Baldwin's time to submit an alert letter. Even if this is true, that grand jury panel was dismissed. And the grand jury that handed down this indictment was a completely different grand jury panel 2 months later. So this indictment was not the result of being jammed through in a 3-week period. This indictment. She requested permission to conduct a one-sided voir dire of the grand jury, jury pool, in an attempt to influence the composition of the grand jury. Maybe she did attempt that, but it wasn't permitted, so there was no harm done. She sought to preclude virtually all of Baldwin's exculpatory and favorable evidence. Again, the word relevance missing here, taking the extreme position that none of Baldwin's witnesses, including Halls, who told Morrissey he feels responsible for Hutchins' death because he failed to check the gun and was the last line of defense, had anything exculpatory to say. Well, they don't. If we mean relevant and exculpatory, relevant to the criminal charge. The court ordered the parties not to disclose the contents of the grand jury hearings and explained that disclosing the grand jury date was highly disturbing because sitting grand juries had read the press and had asked the court to sit on the Baldwin grand jury. Morrissey violated the court's order that same evening and disclosed information about the grand jury and the next grand jury date twice, even after receiving that stern warning and order from the court. Again, what they're talking about here is a grand jury panel that was dismissed. They're not talking about the grand jury panel that returned this indictment that sat 2 months later. So all of this is irrelevant. Even if this were harmful, even if the grand jury panel that was dismissed had been disposed to prejudice, it was dismissed. It's not the panel that handed down this indictment. The madness didn't stop there. The madness. After the court rejected the state's arguments and ruled that Baldwin's witnesses must be made available to the grand jury, and they were, Morrissey refused to adjourn the grand jury date to allow enough time to comply with the court's order and New Mexico law. That's just not true. When Baldwin asked Morrissey to adjourn the grand jury date so she had more than 2 days to present the case, which was not enough time for Morrissey to comply with her obligations, the defense is saying Morrissey had an obligation to present all their exculpatory evidence and witnesses, even if it was irrelevant to the criminal charge. It's true, Morrissey did not have time to present the voluminous, irrelevant exculpatory evidence and witnesses the defense offered, which, of course, the defense did on purpose. But she's not obligated to make time to present irrelevant evidence to the grand jury. Morrissey ignored Baldwin's letter. She's privileged to ignore a letter making ridiculous demands, plowed ahead, presented her 7 biased witnesses, several of which have conflicts that the state concealed from the grand jury, refused to provide the grand jury access to any of the witnesses or documents that grand jurors were obligated to consider. Not true. Issued an improper jury instruction on a critical element of the offense. Not true. And after barely more than 1 day, obtained an indictment. So Morrissey talks about this in her response. You know how much time she spent on this grand jury indictment for a 4th-degree felony? A full day and a half. You know how much time a New Mexico prosecutor typically spends with a grand jury for a 1st-degree felony, intentional murder? 3 hours. So Morrissey spent 5 times as much time on a 4th-degree felony charge as most New Mexico prosecutors spend on capital murder. Morrissey's conduct has been malicious and vindictive from start to finish, consistent with her troubling confession to the media that the prosecution's motive is to humble Baldwin through a teachable moment. Again, zero direct evidence Morrissey ever said this. The defense here is citing a media report quoting an unnamed source that's supposedly quoting Morrissey. The state's repeated violations of the U.S. and New Mexico constitutions, New Mexico law, and the ethical rules further undermine the structural integrity of the grand jury process. What they're talking about here are the prosecutors who initially indicted Alec Baldwin. They did some things wrong. They charged him with a gun sentencing enhancement in a retroactive manner. So that was not law at the time Alec Baldwin shot and killed Halyna Hutchins. You can't apply criminal laws retroactively. So that was a mistake on their part. And that charge was dismissed. The special prosecutor appointed was also in the process of running for state legislature. You can't do both those things under New Mexico law. But that was cured. She was dismissed from the prosecution or resigned from the prosecution. So although these were mistakes made by earlier prosecutors, first of all, the mistakes were wiped, so no harm was done. Second of all, those people and those acts have nothing to do with the current indictment. But let's hear the defense talk about it. The state's misconduct throughout this prosecution occurred on the heels of an equally bad faith prosecution brought by Morrissey's predecessors, District Attorney Carmack Altwise and former Special Prosecutor Reeb, whose constant disparagement of Baldwin in the media annihilated any chance of a fair prosecution. Like Morrissey, Carmack Altwise and Reeb could not hide their disdain for Baldwin, which is why they cut every corner imaginable to push their vindictive agenda, charging Baldwin under a law that didn't exist when the accident occurred. That's the gun sentencing enhancement. Appointing a special prosecutor who was simultaneously campaigning for state legislature. Fair enough, that was a mistake. And disparaging Baldwin and his lawyers in the media when he asserted constitutional challenges to these mistakes, even as they privately conceded that his lawyers were correct. So they conceded they made mistakes, they eliminated the mistakes, and they eliminated themselves from the indictment, also dismissing the indictment. Meanwhile, Carmack Altwise and Reeb were laughing at Baldwin's expense, literally writing LOL at the idea that prosecuting Baldwin could help Reeb get elected. First of all, laughing's not a crime. Second of all, even if this is true, they're no longer involved in this case and have no involvement in this indictment that the defense is trying to get dismissed. Continuing, it is the grand jury's duty to protect citizens against unfounded accusations, whether they come from the government or others, and to prevent anyone from being indicted through malice, hatred, or ill will. The state made sure in every way possible that the grand juries would be unable to fulfill that duty. They botched the investigation. They destroyed the gun at issue. The gun was broken by the FBI. It was not destroyed by the prosecution. It's still in evidence. They violated the U.S. and New Mexico constitutions. Yeah, they applied a criminal law retroactively. That was cured. New Mexico law. That was the prior prosecutor running for legislature at the same time. That was cured. The court's orders. No. And the ethical rules. Again, no. They conducted an improper press campaign designed to destroy Baldwin and taint the grand jury. No, they merely responded to defense appearances in the media, which they're allowed to do. They violated the grand jury secrecy rules, even when the court explicitly described the prejudice of doing so. Again, only in response to defense statements to the media. They misled the grand jury about its independent role in the process and the purpose of Baldwin's alert letter. No, they read the letter. What was read to the grand jury was up to the defense. They kept exculpatory and highly favorable witnesses and documents from the grand jury. What's missing from that sentence? Again, the word relevant. They both elicited and failed to correct testimony from witnesses that they knew to be false. It doesn't matter if it's not material or irrelevant. They both elicited and failed to correct testimony. They read an improper jury instruction about a critical element of the charged offense, which also contradicted their own expert's testimony and summation at Gutierrez's trial. And then they conducted the entire grand jury presentation in barely more than 1 day. Well, they didn't misrepresent the jury instruction. It wasn't improper. And more than 1 day is a lot of time in front of a grand jury for a fourth-degree felony. For the above reasons, Baldwin respectfully requested the court dismiss the indictment, and this was filed on March 14th, 2024. Now, the Friday before last, April 5th, Kari Morrissey and Jason Lewis, the special prosecutors on this case, filed their response to this nonsense. And Kari Morrissey brought the heat in that response. You should watch these two shows first, so you've seen what the defense was actually arguing, of course, in the context of my analysis and commentary. But tomorrow's show at noon Eastern time, our live show, will be the reading of Kari Morrissey's response to this ridiculous motion by the defense seeking to dismiss the grand jury indictment against Alec Baldwin for manslaughter in the killing of Halyna Hutchins on the set of Rust, when Alec Baldwin was handling what he knew to be a real gun, pointed it directly at Halyna Hutchins, pulled back the hammer, pressed the trigger, obviously without ensuring there was not a live round in the gun, discharged that round into Halyna Hutchins entirely through her body, breaking her spine, fatally injuring her, and that bullet continuing on and lodging in the body of Souza, Director Souza. What the heck's his first name? I'm suddenly blanking. Jay? David Halls, and I'm forgetting Souza's first name. Doesn't matter. The director of the film. All right. So I'm going to jump into Q&A. Before I do that, I will mention, of course, Law Self-Defense members get their questions answered for free in the member dashboard. Anybody can become a Law Self-Defense member, as you might imagine. You can try it out for 2 weeks, free trial for 2 weeks, lawselfdefense.com/trial. After that, it's still dirt cheap to be a Law Self-Defense member. Only about 30 cents a day, less than $10 a month. But at least try out the 99-cent trial at lawselfdefense.com/trial. Get all your questions answered for free. Or we'll also look at questions on YouTube, but they need to be $10 super chats. So you're paying more for an individual question on YouTube than a whole month's worth of your questions answered for free as a Law Self-Defense member, but that's up to you. Again, that trial membership at lawselfdefense.com/trial. And of course, you can cancel your membership at any time if you decide it's not for you. No questions asked. And my last mention, because it is the last day for this early registration, our Law of Self-Defense Advanced class on Saturday, April 20th. This is our full-day class taught live by me, streamed to you on Zoom, that teaches you in one day everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. We only teach this class twice a year. So if you miss this one, it'll be October before you can get it again. Check it out at lawselfdefense.com/advanced. We have a list of more than 100 very specific self-defense law questions we answer in plain English. We cover defense of yourself. We cover defense of others, family, neighbors, colleagues, strangers, like an active shooter event. We cover defense of property, everything from highly defensible property like your home down to least defensible property like your pets, believe it or not. We cover interacting with the police in the aftermath of a use of force event. That takes an hour almost by itself because of how subtle those interactions can be. Now, if you can't make next Saturday, this is next Saturday, folks. If you can't make it because you have a conflict, I would urge you to register anyway, because we'll make the playback of the class available for 2 weeks after the live event, but only for registered students. And this is the last day of pre-registration, 50% off the normal registration. So check it out at lawofselfdefense.com/advanced. If you register tomorrow, it's going to be twice as much, folks. Don't do that to yourself. lawofselfdefense.com/advanced. Only twice a year we teach it. Can you afford to wait until October? Do you know when you'll be attacked? When you'll need to have this knowledge on board? It has to be on board before the fight happens, or it can't help you, right? Don't wait until October. Take advantage of this right now. Next Saturday, spend Saturday with me at lawofselfdefense.com/advanced. All right, so let's take a look at what we have for Law of Self-Defense member questions. And again, thanks everyone for joining me this early Saturday morning. Oh, not many. Well, that's what you get for Saturday morning, Andrew. Let's see. Looks like the only substantive question is, how common is it to have a defense file a motion such as this one to dismiss a grand jury indictment? It's not at all common. Very unusual. But part of what we're dealing here with is Alec Baldwin's looking at a felony conviction. 18 months in prison maximum, which isn't much time as these things go, but he's no spring chicken. 18 months of the rest of, that chunk of the rest of his life in prison. Can't be pleasant to think about. He's got 6 or 7 kids. No one likes prison. Plus, he'd never be able to handle a gun again, even as an actor, because of the felony conviction, although his career is probably over anyway. But he's hired a ton of lawyers. So he has a local New Mexico lawyer who's kind of their local face. You have to have that, someone licensed to practice law in New Mexico. But then he's got like 8 or 10 New York law firm lawyers, most of whom do civil work, civil litigation, not criminal work. They're all from a big New York law firm. Some of them are not from New York City. They don't live in New York City. They live in Houston and other places around the country, but they're all employed by the same Manhattan law firm. So very expensive. A bunch of partners, a bunch of senior associates. They're all billing, the partners at least $1,000 an hour. He's paying a lot of money to all these lawyers. So they're going to produce work product for him. They're going to make, they're going to show him this 60-page motion to dismiss the grand jury indictment and to show that he's getting something for his money, even though it's ridiculous on its face to anyone who actually understands the law. We should expect to see a lot of that. Alec Baldwin's bringing a lot of resources to bear to muddy the waters here, as you would expect from someone who has a lot of resources at hand to do that kind of thing. All right, let me check out the super chats. See if there's any from today, and there are not. All right, folks. So with that, I will go ahead and wrap up today's show. I'll just remind all of you that if you carry a gun, so you're hard to kill. If you carry a knife, so you're hard to kill. If you carry pepper spray, so you're hard to kill. If you study jujitsu, so you're hard to kill. I do all those things so that I'm hard to kill. My family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time. I jumped the gun there. Sorry. Until next time. Tomorrow, noon Eastern time, when we'll go over Kari Morrissey's response to this nonsense from the defense. I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.